Welcome everyone to the Center for Governance and Markets virtual seminar series on policing and police reform in the US. My name is Jennifer Murtazashvili, and I'm a professor of public and international affairs here at Pitt, and I direct the Center for Governance and Markets. We're fortunate to have Professor Joe Soss with us to talk about his new book project, Preying on the Poor, Criminal Justice's Revenue Racket. We're even just as fortunate, even more fortunate to have Brandon Davis from the University of Kansas moderating this discussion today. And Professor Davis focuses on American politics and public policy, race and ethnicity, as well as law and society. He was recently appointed by the governor of Kansas to serve on a state commission that's tasked with studying issues of racial equity and justice in that state. And it will begin its work focusing on law enforcement community relations. Brandon is a former predoctoral and postdoctoral research associate at Brown University. His research focuses on American politics and public policy, and he's interested in normative and empirical approaches to institutions, participation, and criminal justice. Joe Soss is the inaugural COWS Chair for the Study of Public Service at the University of Minnesota, where he holds faculty positions in the Hubert H. Humphrey School of Public Affairs, the Department of Political Science, and the Department of Sociology. His research and teaching explore the interplay of democratic politics, societal inequalities, and public policy. He's particularly interested in the political sources and consequences of policies that govern social marginality and shape life conditions for socially marginal groups. His co-authored book, Disciplining the Poor, Neoliberal Paternalism and the Persistent Power of Race, was selected for the 2012 Michael Harrington Award from the American Political Science Association and the 2012 Oliver Cromwell Cox Award from the American Sociology Association, as well as many others. He was also my professor of qualitative methods when I was in grad school. So it's a huge honor to have both of you here today, and Professor Soss, will hand it off to you.
Thank you so much. Thanks for having me. It's a real pleasure to be part of this group, and especially to finally get to have a little conversation with Dr. Davis, who I've been following his work for a few years now. So thanks for having me, and I'm excited to talk to you about this book that Josh Page and I have been working on for a while now, and are about 2/3 to 3/4 of the way through. In March 2015, the U.S. Department of Justice reported that the city of Ferguson, Missouri, had been operating a predatory system of government. Police were acting as street-level enforcers for a program that used fines and fees to extract resources from poor communities of color and deliver them to municipal coffers. Now, three features of this regime stood out. First, the targeting and scale of the operation. Black residents made up 90% of those ticketed for public safety violations, with the city averaging 3 warrants per household. Stop and think about that, 3 warrants per household. Fines and fees became almost universal experiences for poor Black residents. Payments were pursued so aggressively that they made up 1/5 of the city's entire revenue base in 2013. Second, the intentional top-down nature of the operation. The DOJ concluded, quote, Ferguson's law enforcement practices are shaped by the city's focus on revenue rather than by public safety needs. The city budgets for sizable increases in municipal fines and fees each year, exhorts police and court staff to deliver those revenue increases, and closely monitors whether those increases are achieved. And third, the city's construction and exploitation of debt. Even when they were subjected to minor fines, Ferguson residents often became ensnared in a perpetual trap of debts, payments, and revenue-generating interactions with police and courts over and over again. Now, the entire story, when it came out, struck many people as sharply at odds with how governance normally works in American life. And against this view, Josh Page and I in this book join others who argue that Ferguson's regime of plunder was no anomaly. Instead, it reveals a complex of criminal legal practices that is widespread and worthy of far more critical analysis than it's received. So let's begin with a descriptive question. How substantial are these practices, and how have they grown over time? In America today, roughly 10 million people owe a total of about $50 billion in court-generated criminal legal debts alone, and make nearly $40 billion in payments on those debts each year. The revenues they generate flow not only to governments, but also to for-profit firms operating throughout the system. And not surprisingly, given what we know about the system, the burdens of this resource extraction regime are disproportionately borne by people of color. The financialization of criminal justice has grown both wider and deeper over the past 25 to 30 years, with a burst of onset from the late 1980s, early 90s, periods of rapid expansion clustered around 9/11, 2001, and the Great Recession of the mid-2000s. Consider just a few trends of some of the most important sites of extraction. Fines and fees, for example. From 1991 to 2004, the percent of prisoners reporting legal financial obligations rose from about 25% to 66%. Today, all 50 states defray prison costs by charging prisoners some form of pay-to-stay fees, almost always for room and board, but in some states also for medical care, clothing, and basic needs such as menstrual pads. Nearly all states charge people for their own probation and their own parole supervision as well. To secure payments for these fees, officials can seize virtually any money a person under custody might receive. They take percentages of the deposits people put in prisoners' accounts, and they seize funds through the death of a relative, a legal settlement, or even intellectual property. In most cases, these fees produce debts, which states and localities then pursue through aggressive collection strategies for years after a term of punishment has ended. In addition to fees imposed for nearly any kind of court procedure, some states now charge defendants extra fees to exercise their right to a jury trial, and most allow courts to charge people who exercise their right to a public defender. So citizenship rights to have these things in court have been turned into consumer rights to purchase them and to go into debt to pay for them. Bail charges have grown dramatically in number and size over the past 25 years, funneling poor people's money to a handful of large insurance corporations, even in cases where no one is found guilty of a crime. And at each step along the way, as actors create new points of resource extraction, others try to piggyback on it to get revenues for themselves. The process acts as a kind of force multiplier for monetary transfers out of poor communities. So consider, as a small example, what happens if you run a stop sign in California. The base fine for failing to stop is $35. But over time, state and local agencies have added 12 different fees and charges on top, many of which have no discernible relationship to processing the violation. So in the end, after all the various agencies have gotten in on the revenue action, the fine you have to pay for running the stop sign is not $35, it's $238. Or consider civil asset forfeiture. This procedure emerged from the war on drugs and grew in the 1990s. It allows authorities to seize any assets that they suspect may have illicit origins. The burden of proof is then on the owner to show, through a costly court challenge, that the assets have no criminal history. The total value of seized assets rose sharply between 2004 and 2010, reaching $1.1 billion in just 2013 alone. And between 2001 and 2013, $2.1 billion in assets were seized from people who were never even charged with a crime. At the local level, from 2011 to 2013, Chicago police brought in nearly $72 million in cash and assets through civil forfeiture. The money was coming in so fast that they actually used some of the proceeds to buy a cash counting machine for the police department to speed up processing at the office. And they also used some of the slushy funds to buy themselves controversial surveillance equipment that the city council had declined to approve. Now, contrary to political rhetoric, most of these seizures do not involve drug kingpins with yachts and mansions. They mostly take small amounts from people in poor communities of color. A study of Philadelphia cash forfeitures in 2012 and 2013, for example, revealed that half of all the seizures were for less than $192. Or consider prison-based profits. Alongside government takings, prison profiteering by corporations has risen steadily. Today, prison management contracts alone represent a $5 billion industry, with growing revenues coming from detention in the areas of immigration and asylum seeking. In so-called public prisons as well, state authorities have increasingly moved to commodify their control of human bodies and sell extraction rights to market firms. Prisoners have needs, and prisoners can be put to work. And by purchasing access, often in monopoly form, firms are able to exploit prisoners, first as underpaid labor, and second, and more deeply, as captive markets for overpriced goods. Consider pros and phone calls. Capitalizing on inmates' efforts to maintain their social and family ties, Companies charge exorbitant per-minute rates for prison phone calls. The annual value of this industry is estimated at $1.2 billion, with commissions or kickbacks to government totaling more than $460 million a year. And in many cases, firms work creatively to construct new opportunities to prey on prisoners as captive markets. Consider, for example, the new prison market in video interfaces. By arguing that the old, long-standing practice of free in-person visitation posed a security risk, firms channeled social needs that were already being met into more profitable digital formats. In this way, the basic need to maintain contact with loved ones became integrated into the field of financial extraction, and the conversion to fee-based video visitation is now supplanting free personal visits in prisons around the country. And this same process, by the way, is also underway for reading, with states banning book donations to free prison libraries and forcing prisoners to purchase ebooks and tablets to read them on. In other cases, firms leverage the threat of prison to produce market sales under duress. Consider, for example, the case of Vivitrol, a drug that Alkermes Incorporated developed over a decade ago to curb drug and alcohol addiction. After years of failing to build a market with doctors and patients and failing to achieve strong results in controlled trials, Alkermes worked to gain a foothold in the criminal justice system as a site where individuals could be compelled to buy their product. In many courts today, judges offer defendants a simple choice: take the shot and pay for it by going into debt, or go to jail. Now, I can go on, but this quick survey, I think, is enough to establish a timeline and to suggest the scale and diversity of what we're talking about here. So I want to turn to a more direct consideration of some of the consequences of these practices. For now, I'm just going to make three general points, which will have to stand in for a broader discussion we can maybe have later. First, to appreciate the full consequences, we have to pay attention to how predatory criminal legal practices set cascades of debt, hardship, and crisis in motion. An initial violation carries a fine, which leads to court appearances, which have their own fees, which then may usher the individual into the expensive world of the bail industry, which then produce debts that cannot be easily paid. And this debt, in turn, leads to new entanglements with the courts and additional fines and fees and endless payments on interest in some cases, also debt-based imprisonment in some cases. And as debts mount, the significant others that surround the individual are drawn into the orbit of extraction. Social networks and family ties work as a kind of infrastructure for a cascade of financial takings. Limited resources throughout the network, throughout the community, are drained out, often with devastating consequences. So what must be understood here, I would say, is that the targets of extractive criminal legal practices are not actually the individuals deemed criminals or charged with crimes, so much as they are the communities that are subjugated by race and class, which are the real sites of extraction where the resources are. And this brings us to a second point. It's here in asking who bears the financial burdens of predation that a gender analysis becomes essential for getting the story right. Although men of color are disproportionately targeted by our criminal justice system, it's more often women, and especially women of color, who shoulder the financial burdens. Roughly 1 in 4 women in the U.S. have a family member in prison, and that number rises to 44% among black women. And women make up an estimated 83% of family members covering costs for incarcerated populations. It's typically women who co-sign the bail contracts and wind up on the hook for the premiums and the other obligations. It's women who cover the fines and fees and prison charges while men are imprisoned. It's women who take on additional debts when the men return to the community branded an ex-felon and often find they're unable to secure work. Among families trying to maintain contact with a prison inmate, an estimated 1 in 3 goes into debt. And in states such as Florida and Wisconsin, the unpaid criminal justice debts of ex-prisoners who die are transferred to their families and their estates after their passing. Payments on these debts leave many women unable to keep up with living expenses, including food, utilities, and rent, and often play a role in pushing families toward eviction. Third, then, as in terms of consequences, I just emphasize the practices I've described are equally consequential for citizenship and political relations to the state. On one side, these practices operate as a repressive form of social control that takes away freedoms and rights and resources. And in this sense, they work to deepen civic marginalization, to exclude and disempower. But on the other side, these practices also operate as a productive force that constructs new power relations, subject positions, and terms of civic standing. The practices in question do not simply take through force. They generate legal violations and define growing numbers of people as civic violators, working to produce categories of people designated for expropriation and debt-based disciplinary practices. So through this process, the terms of citizenship are refracted, in a sense, through the lens of debt in ways that reconstruct both the moral and, I would argue, the material dimensions of civic standing. Criminal justice debt itself becomes the marker of a distinctive civic status that's rooted in violation of the social contract and therefore punishable, in a sense, in its own right. The drive to generate revenues as well has a corrupting effect on institutions responsible for policing and governing the poor. In Ferguson, for example, the Department of Justice concluded that the courts ceased to act as a neutral arbiter of the law or a check on unlawful police conduct as they shifted to a revenue-centered footing. The drive to collect payments has undermined the full citizen's constitutional guarantee against being imprisoned for debts. And in some states, people may be deprived of the right to vote for no reason other than the fact that they have been unable to pay off their criminal justice debts, Florida being the most infamous example at the present moment. People who can't pay off their entire debts frequently have their driver's licenses revoked, with predictably devastating effects on employment and social relationships. Some jurisdictions now turn off water service to homes as a way to force criminal legal debtors to pay the government ahead of their other creditors who they owe money to as well. Predatory criminal legal practices undermine community trust and cultivate fear and avoidance of public institutions. And they fuel anger and resentment alongside expectations of injustice. In many ways, the continual fining, the continual use of fees, the continual extractive interactions has become a central part of what it means to just move around in the community when you get citations for biking or for walking in the wrong way or driving for small things in various ways. So in many cities, fines and fees and the like have become standard elements of policing operations that manage and discipline the ordinary comings and goings of targeted residents. Now, having said a bit about the practices and their consequences, I want to turn now to two deeper questions, use the rest of our time to talk about two deeper questions of historical and theoretical analysis. First, how should we conceptualize these extractive practices and place them in broader historical perspective? And second of all, returning to the contemporary period, how should we explain why these specific practices emerged in the form they did and when they did? On the first question, Josh and I argue for the importance of understanding extractive criminal legal practices not just as matters of crime and punishment, but more fundamentally as a case of predatory governance. Right? By calling these activities predatory, we want to focus attention, both analytically and politically, on how these practices fit into a broader pattern of group-targeted resource stripping in the United States and America, historically and today. Josh and I use the term predatory to refer to practices that leverage a group's positioning and relations of subjugation, marginalization, colonization, or exclusion in order to pursue expropriative or super-exploitative modes of accumulation. So from this perspective, it's possible to connect predatory practices in the criminal legal field to other contemporary practices that operate by converting social exclusion into what scholars have begun to call predatory inclusion, right? That turn social exclusion into predatory forms of inclusion. So the denial of banking services to poor communities of color, for example, creates people with unmet daily needs who are ripe for super exploitation by predatory payday lenders and check cashing operations. The exclusion from one thing positions you to be exploited in extreme ways as included in a different manner. People held in prisons are set apart socially and spatially in ways that position them for financial takings of many sorts. Their situations are in many ways distinctive, but if we look at the wide array of predatory business models associated with subprime home and auto loans, usurious credit cards, and all the rest, we find a fairly analogous process in which societal practices that set people apart in one way or another through segregated neighborhoods, through carceral settings, all things, the sort of practices that set people apart socially and spatially produce targets for financial takings on the most extreme terms. Similarly, the concept of predation allows us to understand criminal justice takings more deeply by locating them in a longer historical trajectory. The celebrated liberal history of American development has always been premised in varying ways on a less acknowledged history of predatory governance and dispossession focused on subjugated groups. So Richard Young and Jeffrey Miser, for example, argue that, quote, the early Anglo-American state can best be described as a dual state, a predatory state in its dealings with non-white Americans, but a contract state in respect to the internal governance of the dominant group, Anglo-American males. The contract state that, quote, promoted the growth of a prosperous liberal democratic society of Anglo-Americans was made possible by a predatory state that financed white liberal society through its ruthless exploitation of Indian lands and African American labor. In many ways, this analysis jives with W.E.B. Du Bois's argument in Black Reconstruction in America that the enslaved labor of Black workers became, quote, the foundation stone not only of the Southern social structure, but of Northern manufacture and commerce, of the English factory system, of European commerce, of buying and selling on a worldwide scale. From the country's inception, law and law enforcement played a critical role in the dispossession of indigenous lands and the institution of chattel slavery. Constructions of racial difference in the early republic were themselves fashioned and deployed to advance and justify violent takings of labor and land, and to construct a delimited Herrenvolk democracy for white male property owners. Public officials used racial categories and policies and boundaries of citizenship to create excluded groups and designate them as suitable targets for expropriation. In the post-Reconstruction era, new predatory practices emerged through debt peonage and sharecropping, labor-enforcing poorhouses, prison industries, and convict leasing. And once again, governments held these predatory systems in place through legal practices that forbid wage competition among landowners, policed Black so-called idleness and vagrancy, and aggressively enforced debt payments to private creditors. In the North, prison industries turned carceral facilities into factories and inmates into captive labor pools generating private profits. And in the South, chain gangs and convict leasing contracts were used to reconstruct key elements of the old plantation arrangements. Such practices persisted well into the 20th century, and by mid-century, new and varied tactics emerged, particularly around the construction of the hyper-segregated residential ghettos. And again, we could flesh this out in a variety of ways. Much more could be said, but this quick historical sort of refresher should suffice to make the point. The liberal development of civil, political, and social citizenship in America was deeply entwined all along the way with extractive predatory practices. It wasn't that we had, in some sense, a predatory state or a contract state. It's that the two coexisted, with one depending very much on the other. Now, in many respects, Josh and I argue these practices and their symbiotic relationship with legal institutions should be seen as the prehistory of criminal legal predation today. Now, to say this is to suggest that we misunderstand today's extractive fines and fees and all the rest if we only view them, as many observers do, through the lens of crime and punishment, that is, as a monetary form of penal sanction. Right? This brings us to our second historical question. How should we explain why today's predatory criminal justice practices emerged when they did and in the form they did? As a starting point, Josh and I emphasize that the rise of financial takings in the criminal legal field emerged as a constitutive element of much broader changes in the political economy. Since the 1990s, predation in the criminal justice field has shifted substantially from a labor focus to a financial focus. But of course, financialization of this sort is among the most widespread developments in the political economy, treated by many as a defining aspect of our era of capitalism. In fact, as I've already noted, predatory financial practices like payday lending and subprime loans and the rest have become widespread and largely focus on the same subjugated communities targeted by criminal legal predation. The profitable forms of privatization that have transformed criminal legal practices are not distinctive either. Privatization has overtaken most fields of government in governance in recent decades. Public agencies' efforts to monetize criminal justice holdings and practices actually fit comfortably into the much broader process that scholars refer to as marketization of the state. The shifting of fiscal burdens from the collective citizenry to the accused and convicted individuals who are cast as consumers has been part of a much broader shift in this direction. So the dramatic growth of court fees, for example, has coincided with a broader retreat from public funding based on progressive taxation and a shift toward individual level funding through regressive fees charged to users. So government budgets for public universities dwindled and tuition charges escalated, right? Funding for public parks drew less on public coffers and more on fees charged to visitors, and so on. Criminal legal targets are hardly the only Americans who've been recast as consumers who must pay individually for their interactions with public institutions. The key point here is that the transformation of criminal legal practice has in part reflected a broader neoliberal reorganization of state, market, and society. Now, to connect these things is not to equate them, however. Predation in the criminal justice field is in many ways distinctive in its operations and intensity and in how it deploys the coercive, custodial, and coordinating capacities of the state. I'd also argue that the kind of things that I've pointed to so far should not be seen as a satisfying historical explanation in their own right. These are sort of disembodied social forces or structural changes. They're descriptions, in a sense. So we need a much more concrete account of what was done and who did it and why. Josh and my explanation focuses on the conjunction of three broad developments, which I'll try and summarize fairly rapidly. The first is changes in public finance, where we went through a period in the late 20th century where all sorts of new functions that had been up at the federal level were devolved down to states, and then through policy second-order devolution down to localities. And at the same time, the federal government pulled back on federal transfers and supports in many ways. And as that happened, you began to have this structural sort of intense fiscal pressure experienced at state and local levels, which were also the same places that controlled criminal legal practices. In our system of federalism in the U.S., that's where, criminal legal practices are controlled for the most part. So there was a need for new resources, desperate need for new resources as federal government devolved obligations and took away federal transfers. But the hands of state and local governments were increasingly tied. After Proposition 13 in California in 1978, nearly all American states restricted local governments, and in many cases state governments' abilities to raise funds. States increasingly turned to regressive revenue strategies like state lotteries and sin taxes and sales taxes and all of that, and they began to take funds that were supposed to be for public assistance programs for the poor and mix them into general revenues. They pursued all sorts of regressive revenue strategies here to take care of the problem, but they were not really enough. And so in many places, what you got were aggressive cutbacks to services, a kind of austerity politics, where you began to see all sorts of things that local governments had been doing before they no longer were doing. The question is, why didn't that happen in the criminal justice area? And in the criminal justice area, there's a fairly, at first simple, but more complex story the more you take it apart. You couldn't really cut back criminal justice operations because by the early 1990s, law and order politics, tough on crime politics had become a kind of bipartisan political juggernaut. There was really no way to say we're going to pull back on this. You had highly mobilized interest groups, you had both parties' leadership pushing hard, and so that posed a major barrier to sort of cut things back in a similar way. At the same time, the U.S. criminal justice system is organized in a highly decentralized way that made it very hard to have any sort of coordinated effort to pull back these operations. And in fact, within this fragmented system, the people who were generating costs oftentimes were not the same people who were absorbing those costs. So you had courts overwhelmed by the number of cases coming in, but those cases were being generated by police departments that they didn't control. Or you had state prisons that were overwhelmed with the number of prisoners coming in, but those were being generated by prosecutors and police at the local level and judges at the local level. So the various kind of institutional divisions made it very difficult to sort of put the brakes on this way. But at the same time, this same racialized Politics of criminal justice and law and order serve to advance criminal justice predation. Get tough political pressures and discourses fueled and legitimated the conversion of criminal justice operations into sites of revenue generation. So in the name of getting tough on crime, officials created new violations and added fines and raised fine levels. In the name of protecting taxpayers from a further fleecing at the hands of criminals, they piled up fees of all sorts, from pretrial through court appearances and on to probation and parole. In the name of public safety, they expanded the scope and size of financial obligations that they imposed for bail. In the name of an aggressive war on drugs, they expanded asset forfeiture, and on and on and on. Now, to many desperate public managers, these actions appeared to offer a win-win, a kind of meeting of virtue and necessity. They were getting tougher on criminals, they were pursuing public safety more vigorously, and they were meeting the community's significant fiscal needs all in one swoop. An institutional lens here, I think, also helps us understand the distinctively financial turn in criminal justice predation since the 1990s. If you look back from slave patrols to convict leasing and beyond, criminal legal codes and practices in the U.S. have predominantly supported labor extraction. Right? The significant change after the 1980s was a shift in relative emphasis toward financial extraction, which now blossomed beyond any previous experience. Now, part of the explanation for this shift, we argue, lies in the growth of institutional capacity, the construction of this sprawling system of policing, adjudication, and punishment. Taking a page from Theda Skocpol, we can say that policy innovations are always shaped and constrained by the nature of available administrative capacities. Labor supply is something poor communities offer in abundance, and local public and private interests can benefit from, even in modest amounts, even 15, 20 workers in a local setting. The comparatively small criminal legal institutions of earlier eras were quite capable of meeting those sorts of needs in local jurisdictions. By contrast, in poor communities, small amounts of financial resources are spread across large numbers of people. And as a result, financial extraction has to occur at a very high level of scale to generate meaningful revenue streams for public and private institutions of any significant size. From this perspective, even the local finance crisis of the 1970s happened too early for direct financial extraction to work at a sufficient level of scale. The upward spiral of policing and incarceration was at that time really just getting underway. But by the late 1980s and more so into the 90s and all the more by 2007, the necessary conditions of administrative capacity were in place. Massive criminal legal institutions, bolstered by a range of new technologies, turned financial extraction from poor communities into a viable and highly lucrative possibility. And of course, by this time, what state and local public managers were desperate for was not labor, it was finance, right? They had powerful motives to extract financial resources, and with the rapid growth of administrative capacities, they now had the means as well, right? Finally, growing fiscal pressures and tough on crime politics coincided with a third key development, the privatization of American governments. As criminal justice expenditures grew, market firms were presented with an attractive new opportunity for investment, and their entry into the field shaped the trajectory of predation in multiple ways. As for-profit actors flooded the field, they brought along the conventional revenue-maximizing focus of corporations and shareholders, and these actors also changed power dynamics in the field, filling policy networks with well-heeled advocates for payment-centered innovations that were often brokered to include kickbacks to government agencies. State and local officials increasingly moved through a revolving door between public and private institutions, serving, for example, as the head of a state's Department of Corrections, and then as a top executive for a prison company, and then perhaps later returning to government in some capacity. Corporations flooded local elections with contributions that community groups really had no capacity to counter. They hired established insiders to lobby for them and pushed hard to expand the reach of extractive operations. In a lot of ways, this process operated as a classic political science story of policy feedback and changing scope and bias. New policies drove expansions of policing and punishment, and these expanded operations and expenditures then drew revenue-focused actors to the field. And as those actors entered the field, they changed the scope of combatants expanded the scope of combatants in the field in a way that shifted the bias of power relations. Public managers desperate for funds to keep the lights on came together with powerful corporate interests seeking profits, and the two groups worked together to create a variety of new revenue-centered public-private partnerships based on stripping wealth from subjugated communities. Essentially, what we're witnessing here, what we're talking about here, is the creation of a vast network of predatory public-private partnerships. Okay. So I've covered a lot of ground and spoken for a while, so I'm going to end now with some brief comments on resistance and the prospects for meaningful change. As America has concentrated wealth and shielded it from taxation in recent decades, it has also developed what amounts to a new system of not just regressive, but expropriative taxation, drawing resources out of our poorest communities. To attend to these practices is to remind ourselves that people are not poor in the U.S. simply because of the lack of human capital or the weaknesses of well-intended social policies. People in this wealthy nation are poor in part because powerful state and market actors work creatively and continually to strip resources from their communities. Predatory criminal legal practices play a vital role in the social and economic hardships and indeed the second-class citizenship experienced by large numbers of Americans today. But these practices have not gone unchallenged. We are, in fact, surrounded by determined efforts to fight these injustices and significant new opportunities to make progress. Criminal justice predation has been a central issue of contention in the Black Lives Matter movement, in prison labor strikes, and other disruptive protest actions in recent years. More conventional advocacy groups are also mobilizing on these issues. Efforts to reform predatory bail practices, for example, to limit bail amounts based on defendants' ability to pay, are making headway in many states. And legal advocacy groups have won victories to curb the most predatory municipal practices. And in 2019, the fight against asset forfeiture had a huge victory in the Supreme Court, the U.S. Supreme Court in the case of Timms v. Indiana. In the U.S. today, predatory practices pursued in the name of criminal justice present us with, I would argue, a profound case of injustice that in many ways underwrites, subsidizes the quality of life for more advantaged Americans. There's no question in my mind at least, that change is going to come to this state of affairs. To conclude that things are not going to change is to imagine that our present moment stands apart from all preceding history, when things have always changed in some way. The question is not whether things will change. The question is how they will change and what role we, as scholars and citizens and fellow human beings, will play in that change. Thanks.
Great, thank you so much. There's a lot to think about there. So what I'd like to do now, Brandon, I know if you want to respond.
Yeah, I mean, that was excellent, Dr. Soss. I guess I like a point on the citizenship and then one on the predatory governance. I think a lot of times when we're talking about, like you said, or you included with those policy feedback effects, and you're talking about these legal financial obligations, all of these economic resource extraction, networks that these poor people are living with throughout the carceral state. I think it begs us to expand our conception of what resource policy feedback effects are. And so we look at resource feedback effects as things the government gives us, and it's good for us. It's a GI Bill, it's an earned income tax credit, but the government can also extract resources. And so those feedback effects from that extraction is, I think, a lot of is having those negative feedback effects through the ideas of citizenship, alienation, and the like. So your comments on that, and I think the predatory regimes are most apt because it's very difficult to pass a law against, you can't pass a law against me, but you can pass a law against people that look like me in my age group, in my socioeconomic status group, whatever. And you can also pass like de facto laws against, or extractor predatory laws against people that live over there. And so it means a lot how segregated a city is or how integrated a community is, because it's easier to extract things from people if I know where to find those people.
That's right. Yeah, I think that absolutely. I think that a lot of this depends on a kind of infrastructure for extraction. And some of that infrastructure is legal and institutional and has to be built. And that's the process we're seeing here. But it also depends on a spatial infrastructure on the community. It's been built through a lot of policies that aren't about quote unquote criminal justice, right? In a lot of ways. And I think that, you see that in part of this book. Part of the book is a 3-chapter extended case study of the bail industry that I didn't talk about in the talk today. My co-author Josh Page worked as a bail bond agent for a year and a half, and sort of participating at the front lines to see how this industry worked. And one of the things that was remarkable was the way in which bail agents would be quite explicit about, if they didn't have information from the docket about the individual's race, they would look at the addresses and they would go down a list and they would say, black, Somali, Latino, white, and they would basically run down and racially categorize people based on spatial signifiers. So I think that's very much embedded in how it works, how social structure guides practice. On the issue of resource policy feedback effects, I just say that, in some ways, I think part of what this work reminds me of in that regard is, I think Paul Pearson's work has been so crucial for a lot of us in thinking about policy feedback over the years, and this distinction does a great service in a lot of ways between resource and interpretive effects. I also think, like any distinction, any conceptualization, it has its limits, and it introduces blind spots. That's true of any concept. And so as good as it is, I think, one thing that the way people distinguish between resource and interpretive effects is often based on this idea that, well, I could help your group by delivering resources that you can use, material resources, or I could help by sending a message that you'll be listened to in government or something like that. But when we're talking about these resource extraction relationships, meaning making and interpretation is inseparable from what's happening with resources. When you are being preyed upon, when you can't leave your house, right, without getting cited for walking wrong, biking wrong, driving wrong, when you're constantly being pulled into courts and having these, how do you separate the resource and interpretive? The material and the ideational are just so entwined. And I think that in some cases in thinking about interpretive as separate from resource effects, we've not paid enough attention sometimes to the symbolic importance of material takings.
Any other questions? It was Sasha.
Hi, how are you doing? Thank you for this fascinating talk. I was thinking as you're talking about kind of the policy feedback loops, where you see the potential sources of institutional change in this. I was thinking a little bit of like Mahoney and Thalen's work, right, and how they conceptualize different actors as being positioned more or less so to result in institutional change. And I think you were talking about this a little bit towards the end. And if you can expand a little bit on if you see that mostly coming from like outside the institutions or within them themselves as well.
Yeah. So, I think that part of the problem now is, I think that's a great question, by the way. Part of the issue now is that we're now, this is pretty recent. So it's within our living memories, many of us in this group, some of us at least, when we had a system that didn't operate in this financially extractive ways, right? Before the early 90s. But at this point, we've reached a stage of sort of path dependency, where the way tax politics and revenue politics often works is once you've relieved powerful groups of taxation and you've now found substitutes in some ways, you become dependent on those, and the system runs on that, and so it becomes very hard to get off that path in many respects. And you see that in all sorts of ways. There have been cases where people are like, hey, we can't let the prisoners out because we need those prisoners to fight the wildfires in California, right? Or there's all sorts of things where people are sort of like, whoa, you can't reform this and roll back these fees and fines because that's how the court runs now. right? That's what pays for basic operations. So we now confront that in many ways, and I think that one of the things that was becoming one of the things that I was emphasizing before is that outside actors really have to apply tremendous pressure. You're not likely to get change here without protest and disruption and the affected communities really leading the way in a lot of ways. But the U.S. system of federalism and decentralized fragmented powers creates lots of opportunities for institutional actors to push back. The most obvious actors in this case, which a lot of people have sort of lost sight of now that we've been under the Trump administration for 4 years, which has been, of course, pushing for more of this activity in all sorts of ways, is that at the end of the Obama administration, there were a number of very direct statements from the federal government, from Attorney General Loretta Lynch said some things about there was a fairly concerted attack on profiteering in the carceral field in prisons. There was even some discussion of asset forfeiture and some back and forth about the equitable sharing program, there was a lot of movement. And I think that within government, there are a lot of actors, particularly at the federal level, that with the right leadership at the federal level, could be mobilized, because this is really something where the dependencies are greatest at the state and local level. So it's not the case right now that the federal level is where you want to intervene, but with a different administration that was more committed sometime down the line, that may be a real important site.
So actually, I have a question for you about the path dependence, right? I mean, this is something that sort of, I think a lot about is how you break these sort of vicious cycles. Mm-hmm. And so do you think that it's really only through mobilization? I mean, that's what we sort of know from this literature. How are there other ways that you think that this could be broken? I mean, through change of administration, but even through, changes, we see a lot of continuity, right, across administrations, that these kinds of changes are really, really stubborn, very sticky.
Yeah, absolutely. And I think that's the difficulty, is how sticky this is likely to be now that we've sort of taken steps down this road. Certainly the Obama administration never attacked this in any way, and in some areas it grew tremendously. I mean, the story I just told is all pre-Trump. Pretty much. It's gotten worse in some areas, but this is not about what's happened under the Trump administration. It grew dramatically under the Obama administration, but there were people positioned to challenge it. Now, the other thing that I would say is, unlike stories about this and historical explanations about this that really emphasize crime and punishment, a sort of culture of punishment, which I think is right in many ways, like Alexis Harris's work, people working on monetary sanctions, I agree with much of their analysis as far as it goes. Part of the issue, though, for me is when we focus specifically on this as crime and punishment, is we lose sight of the public finance side of this, the privatization side of this. And my argument would be there is no road to dealing with criminal justice predation that doesn't run through tax reform, right? Like, to the extent that we have path dependency because localities have become dependent on it, they're dependent on it, they will continue to be dependent on it so long as we're not raising revenues in a more progressive way and we don't bring adequate funding. If we're trying to run government in a way that public managers don't know how to keep the lights on, they're going to look for where they won't meet resistance as much, who's less powerful, to try and get those revenues from. And so in some of this, it's, I find it is reassuring that we don't have to focus only on the politics of law and order and the politics of crime and punishment to potentially make some progress and create openings to get off this path. Right? It could be part of some other broader set of actions as well.
Right. David Skarbek. I should ask everyone to introduce themselves in case they haven't met.
Hi, Professor Soss. I'm David Skarbek. I'm a political scientist at Brown. I really enjoyed your presentation. I think it's a phenomenal project. I'm really excited. I hope you finish it soon. I want to dig into it. I think you tell a very persuasive and compelling account of the United States and the historical progression of this. But I'm curious a little bit, I didn't get a good sense about how much sort of subnational variation there is within the United States. I know that some states at the state level pass laws that limit how local governments can use these sort of extractions that they're able to bring out. So like how much variation across the US is there? Are there places that are sort of really extractive, and why is that? And there are places that have managed to avoid this in some way, and why is that? So could you maybe sort of talk about what variation exists, and from your sort of theoretical framework, how do we make sense of that variation?
Yeah, that's a great question. There is a lot of subnational variation. In fact, there's so much subnational variation that we don't know how to really describe that subnational variation because some of the variation comes in the form of reporting. Like, for example, we don't even have basic sort of national estimates of how much money is being extracted from communities because people have not cared enough about this. People are in power to actually force documentation of various things that are happening. And reporting procedures are so varied across the country. We sort of do the best we can, cobbling together various things with pretty, in my opinion, pretty poor measures in many cases. But we do know some things in some areas. And so, for example, we know that the cross-jurisdictional municipal variation, for example, in the extent to which fines and fees are imposed appears to correlate very strongly with racial composition, with larger black populations being highly correlated with more extraction. We know that it also budgetary pressures tend to lead to more of it, and so that helps explain some of the variation. And oftentimes those things go together. So, in a wonderful study of the Chicago area, Pasowitz and Robinson, that they've done recently, they basically show that if you look in the sort of middle-class suburbs around Chicago, the white middle-class suburbs and the black middle-class suburbs, you tend to get pretty similar views among public managers about what good revenues are and bad revenues are. But the difference is that the white middle-class suburbs are able to attract business investment in a way that's much harder for the public managers in predominantly black middle-class areas to do. And so as a result, because they don't have the same options, race really helps to intersect with class and public finance in a way that they wind up relying disproportionately on these predatory revenues from criminal justice, right? So the last thing that I'll say about the variation piece is there's different kinds of questions you can ask here. I mean, Theda Scotchwell and Linda Gordon had this argument about the welfare state and gender years ago. You can ask questions about variation, and that's very useful. That gives you one kind of explanation. Why did this place do it earlier than another? Why did this place do it more than the other? But you can also ask questions about broad structural change sometimes that are at least as illuminating, which is, why did almost nobody do this prior to this period, and then 15, 20 years, almost everybody's doing it? Yeah, there's variation, but it's a different kind of question to ask about that historical transition as a form of variation, then why does it vary in terms of timing and place in some sense? And we're a little more focused on that question of why did we make this transition to it being extremely common, if variable, from a time when when it was really about labor predation on a much smaller scale.
Great. Do we have other questions?
Yeah. I have a various questions. We talked about that devolution, right? And that public finance and the devolution of public finance. And that devolution also affected the welfare state.
Yeah.
So when you're looking at interaction between race and public assistance, you see that devolution created a push to penalize poverty, but also a reduction in the amount of resources given out to people, and the perception thinking that they were going to give it to minority people. But you see an opposite effect in the devolution when it comes to criminal justice, to whereas it is an increase in resource extraction.
Mm-hmm.
And so I'm questioning your thoughts about that, because it seems like you have a simultaneous, like scaling back of assistance, and also the same state, we're talking, the state is also simultaneously putting another arm behind them to extract money from them. So it's like almost like, I would say give and take, but it doesn't work together like a give and take.
Yeah, well, I think that those are both elements of a single thing, which is, if you look at the agenda, the longer we worked on this project, the more important the Reagan administration became to us in some ways. When you look at that period, when a sort of attack on the welfare state, attack on federal taxation as the most progressive taxation, you see that push to like undercut the funding of government, to shed responsibilities at the federal level, push them down to states, and then cut off that funding, those transfers from the federal government to the states and localities. The plan, in many ways, the project was to sever connections between Washington, D.C. and what was called places of need, which were disproportionately places where people of color and in poverty were concentrated, right? And as that process happened, I think you got a predictable pattern of austerity politics in which many kinds of services were cut back, welfare provision was cut back in many ways, and those programs became much more disciplinary and about serving businesses and producing workers in various ways. And at the same time, you got this expansion, the sort of, it's kind of like Charles Tilley calls it the protection racket of the state, right? The protection racket shifted from the kind of risks that we're protected by the welfare state against, risks of disability and poor health and loss of income, toward the various kinds of protection against threats that were racialized, in the form of immigrants, and in the form of the war on terror, and in the form of thugs and gangbangers and all these sort of symbolic images. And what happened was that we rolled out those services. We expanded all of that, but we built into it a kind of resource extraction operation that helped fund it. Because frankly, as much as people say there's support for popular support for how much we do in terms of policing and punishment, I think it's an open question whether Americans would be willing to truly pay the tax burden that all of that costs. Much of it is defrayed through these kinds of operations.
So I have another question. I'm just, as someone who doesn't work in this area, I'm just really curious to see, of course, you mentioned that the Trump administration obviously hasn't been supportive of many of the kinds of initiatives that you would think would reverse this. Yeah. But one of the things that I'm really curious to think about as we move forward is there's been a lot of efforts, to criticize the president, but have there been efforts? I'm not seeing a lot of really good debates, policy debates taking place right now. And this is the thing that really bothers me about moving forward is there's such a focus on the president, but not constructive ideas about how to move these kinds of things forward. And I'm wondering if you've seen anything, whether it's from members of Congress, from governors, from other policy actors who have come up with creative solutions, maybe even at the subnational level, although that the problems you've discussed go far beyond what happens at the subnational level. But are we seeing some kind of interesting, not to get to David's variation question, but are there little laboratories that we can look to, or policy entrepreneurs who are kind of developing ideas to help us move forward?
So the short answer is yes, but I also kind of want to push back on the question a little bit, Jennifer. I work at a school of public affairs, and that's our go-to idea. Like, where do we see people experimenting with things that can work? What are the policy proposals? Where do we see the good ideas cropping up? I don't think we have a shortage of ideas at all. I think what needs to be done is fairly obvious. We need to raise revenues from people that have them, and we need to abolish these practices. And I think we run systems and have run systems in all sorts of ways without doing this kind of predatory bullshit. Excuse me.
Right. No. So I agree with the premise of your question. I guess that what I'm saying is that people haven't developed ideas, but they haven't developed ideas that are capturing the broader imagination. I think that's sort of the issue, right? It's that we're sitting here talking amongst ourselves, but have you seen someone, that's where I'm, speaking about a policy entrepreneur, we're good at coming up with ideas in our in our academies, right, in our policy schools. But I'm really wondering, if you've seen anybody take these ideas and really be able to mobilize people behind them who have been able to successfully mobilize change for some of these issues at the subnational level, or are there people at the federal level who are particularly focused on this issue?
Yeah. Again, I would say I think that's a really good question, and I like the way you put it. It's about mobilization. And the question is, I don't think it's about that we need ideas to mobilize, that we lack the ideas to mobilize people. It's that we lack the mobilization and the power. Part of the politics here is, look, if, on the libertarian side, hardly a month goes by that Reason Magazine doesn't publish a fantastic article about what's awful about asset forfeiture. And it's such an incredible, and there are lots of other libertarian sources of criticism of government takings that are going on here that are fantastic, and there's all sorts of political potential there. And not a month goes by that you don't find Mother Jones or The Nation or, someplace writing about corporate profiteering. And of course, just like libertarians like focusing on big government's takings, on the left, the focus is in liberals, and so the focus is oftentimes on corporate profiteering. That's why you got the Obama administration decrying the corporate prison corporations, but not saying much about what's going on that the government's doing, taking money through prisons and all of that. So, and it's hard to build a coalition across those in some ways because they want to focus on things that fit their own narratives. But if you look to the communities that are being targeted, there is tremendous grassroots organizing around these issues. There's great effort to try to build. There are a lot of people who are outraged by these issues. And I gave a talk, a community talk, and I was talking to some people, and I described all these things. And the number of times I've given this talk in academic settings that people have been shocked to learn all these practices. Person said to me afterwards in the community talk, they were like, well, everybody knows that. Why are you researching this? Everybody knows that. And so, this is about, educating the people who benefit from this system about what people who are experiencing and already know is happening, and about getting people to mobilize in ways that have real power to try and change it. I don't think I read it as one of those situations where, okay, we really need the good idea that people are going to get behind in some way. In some ways, it's about abolishing unjust practices.
Yeah, I think that there also has been talking on the state level about getting rid of like cash bail and cash bond. I would also say that I think this happens a lot to a small group of people.
Yeah.
So the idea that everybody knows what's going on, I think it for us it seems like a lot, but it only happens in a city. It could be just a few census tracts that this is happening to, and so the rest of the town has no idea. And I think we also are ignorant to the amount of these fees. There was a New York Times Daily podcast, and this guy, they're trying to pay people. They were talking to paying the people's fees to get them to register to vote in Florida. And one man owed $200,000.
Yeah.
There's no way on God's green earth an ex-felon is going to be able to pay off $200,000 in fees. And so that's essentially them taking his voting rights away, and through fines and fees, through exorbitant fines and fees.
Absolutely. I mean, in Florida, when the Republicans in Florida counteracted the Amendment 4 vote by saying, well, if you haven't paid off fines and fees, you haven't finished your sentence, in a sense. They knew, they had internal studies in the state that showed that 83% of people who had those debts, those legal financial obligations, would never be able, they estimated,
never be able to pay them off. Yeah.
83%. And, it's the same model as the payday lenders. You get your hooks in someone, and then you charge interest. They can never pay off the principal. The interest keeps rising. Here, it's not necessarily an interest mechanism, but it's the mechanism of you keep calling the person into court. Every time they don't come, they may not even get they're not going to get all the notifications that they got to come. Eventually, they don't come. You fine them for not coming. They get more fees for each time they come in. It grows and grows and grows. You can owe $600 and wind up paying $1,200 on it and still owe $500 on it. I mean, it's, With Philando Castile got killed by a police officer here in Falcon Heights, in Twin Cities where I live. The Minneapolis Star Tribune did an investigation. He owed $7,000 in citation. He had 82. I think it was 82 different citations, 40 of which, half of which were for driving with a suspended license, which was suspended because he hadn't paid off his fines and fees.
Yeah.
We have a question from Tate Fagley. Tate, if you could introduce yourself.
Yeah, hi there. My name is Tate Fagley. I am a postdoctoral fellow at the Center for Governance and Markets. And I wanted to ask about the defund movement, to the extent that that would be successful in reducing the portion of police budgets that are from tax revenues. Do you think that might affect predatory policing at all? Or are they just already maximizing and wouldn't change at all?
Yeah, well, it depends. I mean, I've actually commented that some of the discussions of defunding the police worry me because they're not paying attention to what happens when, criminal legal institutions get strapped for funds. They often turn to extractive methods to backfill. But I also think that probably the majority of people who are pushing groups, organizations that are really advancing the defund sort of agenda are very aware of these sorts of dynamics and actually consider defunding the police to include not only taking away their sort of official tax-based funding from government, but also taking away these tools of self-funding in various ways, and have actually attacked contracts with universities and other sources of funding as well. So I see in some ways a lot of room for dovetailing between efforts to combat these practices and the broader defunding movement. The other thing is that what you're dealing with is a mismatch, a structural crisis that's sort of ongoing, of a mismatch between operational expectations and expenses, right, and actual funds available to do that. And so as you talk about, as the defund the police movement has talked about, let's take certain functions away from the police, right? A lot of those functions are things that if you talk to police officers, they don't want to be doing anyway. They're not trained as mental health professionals. They're not trained to deal with a lot of these situations. They don't like having to constantly deal with certain kinds of social problems. They'd like to focus on other things. If you can focus them on a smaller number of things, you actually may have fewer operational expenses and ease up some of those pressures in some respects.
Thank you.
Yep. Caitlin?
Hi, thank you so much for your presentation. I'm also looking forward to when the book is published. I was wondering if you could talk more about sort of avenues to address this sort of huge financial system that's been developed in the criminal justice system. Because I thought, and maybe I missed something, that you suggested we need sort of federal leadership to change, sort of shift how the whole system operates. And I was wondering sort of about that, just because from reading Naomi Murakawa's work, she suggests that it's federal intervention that really drove a lot of the growth of the carceral system, and especially the racial disparity in who's affected by it. So I was just wondering what you thought about that.
Yeah, so that's a great question. So I think the politics of federalism is fascinating here. Well, to me, it's fascinating in a lot of ways, in a lot of places. But I think that political science has not had a lot to say about criminal justice, in part because our focus is so national, and because criminal justice is really a local and state level phenomenon, as Ted Lowy once said. In the United States, all social control is local, and so I think that in some ways it's weird to talk about the federal government as leading these things. But I think Naomi Murakawa is right that you have to understand the way in which, even though control is at the state and local level, action is incentivized, and action can be guided and channeled from above, from the federal government. So in the book that I wrote with Sandy Schramm and Rich Fording, Disciplining the Poor, a lot of what we wrote about was how this devolution revolution to giving the states control over welfare policies actually was a way of sort of creating an illusion of freedom in which the states were being disciplined to do particular things. I mean, the states were being strongly incentivized to go in one direction and not another. So in many ways, it was a reduction of state freedom, right? And in this way, I think if you look in the criminal justice setting, just as Merkawa is right, that you have to look to the way the federal government set things up to understand the expansion, right, and the investments and all of that. You also have to look to the ways in which the federal government can set incentives in place and send strong signals that can. So I think that you're likely to get in some ways reform pressures from below that operate at the local level, and you also have some opportunities potentially for some federal pressures. But I think if you get those combined pressures from those two directions on state and local governments, you would have much stronger conditions for change, in some respects.
Thank you.
Yeah, thanks.
We have more hands raised. Perry.
Hey, Perry Farrell at the, can you guys hear me?
Yep.
Yeah, cool. Perry Farrell at the Menard Family Initiative at UW La Crosse. So I agree, like the, policing for profit obviously is, spiraled into something I don't think it was ever really intended to be. But going back to the Beckerian framework, we, those fines still serve an important, deterrence effect, right? And we know, increasing the punishment costs a lot cheaper than, increasing the probability of detection. And so if we were, to say strip away all of the, how do you mentioned tax reform, but like, what would the ideal, punishment system look like? Because like, I don't speed in large part because I don't want to pay the fine, right? Mm-hmm. How do we achieve that sort of dual mandate, if you will?
Yeah, well, I mean, getting into what the ideal criminal legal system would look like is probably beyond the scope of where I can go today. But obviously there's debates about whether we should have, prison abolition and all sorts of things. But what I would say is, in terms of our work, we're not saying that anything that takes the form of a fine would be a case of predation, right? What we're saying is that systems that for a long time have had fees of some sorts and fines of various sorts evolved into a system that became primarily about resource extraction in many respects, and that actually undermines the functions of law enforcement that we need if we're going to be a democratic society based on the rule of law. You need to have law enforcement. Right? That is what prevents the most powerful people from doing whatever the hell they want all the time, oftentimes in violent ways. And so this is not anti-law enforcement, and it's not anti-punishment in all forms. But what has happened is that the rapid expansion of these things have turned it into, is not really justified by, in any way, the legal enforcement sort of functions of fines. The rapid expansion has been about revenue generation in many respects, if that makes sense. Do you want to follow up on that, Perry?
Well, yeah. So, okay, yeah, I agree. I'm with you there. So, how would say like several Nordic countries use they have a like fee or fines as a percentage of your income?
Yeah, they'd use like day fines and things like that.
Yeah, and like I think like a speeding ticket in Norway is like 5% of your annual income or something like that. Would you see like, so how would that kind of fit into your framework there?
Yeah, I mean, I think that people talk about ability to pay, and it's usually in terms of a floor that once you get below a certain level, they're not going to charge you, or that people who are poor, right, that they determine your ability to pay and set the amount at that level. But of course, they don't move in the other direction. They don't say, if you have greater ability to pay, we're going to fine you more, right? And that, I think, is part of what you're getting at, is that when you do it as a percentage of people's annual income, you actually impose fines that bite equally in some ways for people, or more equally at least. So there are a variety of ways to try and get at those things. But I think that what we need to sort of, and I think here, to go back to Jennifer's question earlier, I think there are some really important questions of design. There are some really questions about how do you want the ideal system to look in some ways. But I want to come back to just not losing sight of the big picture, which is that, so the United States is one of 2 countries in the world that allows for a commercial bail industry to profit off of people who have not been convicted of anything being put in jail pre-trial when they're accused, right? 2 countries, us and the Philippines. And, and so we choose to have that system, and it's created this massive lobby that's powerful, that has pushed to maintain this. And it's this huge extraction operation. And, from all that we know from experiments around the world, different kinds of analyses, financial conditions of bail are no more effective than other conditions of bail. We don't really gain anything by doing that. We create a money-making system. And so I think when we get down to, I think once we've sort of worked to really scale back all of these things, yes, there are going to be some important fine-grained questions about exactly how do you define, how do you design the remaining fines, what sort of fees are legitimate, this and that. But we're so far from that right now I think the crucial questions are not those questions. They're, how are we going to sort of abolish the present system that we have, which is, responsible for taking from the most subjugated communities in our country just billions and billions of dollars.
And that's like the tickets and the court fine is a piece of that whole pie. So like having to force inmates to purchase certain food items and health items and health insurance, having to pay to call people, pay to use the internet, pay to get reading materials. That's another huge section. We have 2.2 million people incarcerated. It's another huge section.
And
there's a lot of big pieces to this pie.
Seeing it all as one part of one thing is part of what we're trying to do by changing the frames from, say, monetary sanctions in courts, which is mainly fines and fees and that sort of things, restitution orders, to this bigger notion of predation, is to get all that together. Because, of course, we used to see paying for prisons and for the needs of prisoners as part of the price of civilization, the price of having a society of polity based on laws. That, when people violate the laws, you incarcerate and you pay for that. But we've now moved to this situation in which, I interviewed one person who worked for one of the carceral companies who told me, we have the food contract and we also have the vending, and then we got the vending machine contract. And we got the vending machine contract. We actually cut back on the calories that we were serving the prisoners with the food contract so that they would buy more food from the vending machines. That's the level at which this stuff is just like, kind of mind-blowing and upset, just deeply disturbing. So I think we have to grapple with all that stuff before we get to the really fine-grained questions of sort of, okay, what are we going to do with the remaining stuff?
Yeah, that squares with kind of what I was thinking a lot. Obviously the worst parts, the worst institutions here, all the follow-on effects, not necessarily like say the initial speeding ticket, and the reforming the monster from the tail back to the head will get the worst parts.
Yeah.
First, I think.
When I said, it's $35 for running the stop sign, it's $238 once you've added all the other stuff on top. If you add zeros to those, you get the equivalent sort of thing for what happens with a DUI, right? But it changes by that magnitude. And if you think about that initial charge, some people can't afford that. But basically, you're talking about something manageable when you're at that level. And we can have a conversation about sort of reasonable levels to define a fine at when we're down at that. But with the sort of piling on that happens because all these public agencies are trying to keep the lights on because they're starved for funding, right? And being asked to do too much with too little, that's where you get things that just, get out of control.
And also who gets tickets. So it wouldn't, if the ticket was fair, the amount was fair, that would be fine. But if this side of town gets more tickets than that side of town, it's still an extraction.
Yeah, I mean, this is incredibly important, Brandon. I mean, the notion of whose lives, who is sort of deprived the very air of their communities through all of this fining. If you look at the Chicago study, I think that overall across Chicago, biking is as popular, if not more popular, in affluent sections and predominantly white sections of Chicago as in the poor sections and the sections that are predominantly people of color. But if you look at the biking tickets, 10 out of 10 of the top fined areas for biking violations are all predominantly Black and Latino. And so, it's not just a question of sort of having these procedures, it's that these procedures are targeted on these particular communities. And our argument is that the procedures have actually come into being in many ways precisely because they're targeting these communities, right? That they're ways of siphoning money out of them.
Great. Do we have any more questions? Tate, your hand is still up. I don't know if that's a follow-up or it's hard to bring our hands down on Zoom. Any other questions? So can you tell us a little bit more about the book and when we can expect it? And
yeah, sure. So the book is under contract with University of Chicago Press. And Josh and I we've written there's about 10 main chapters. And Josh and I have 7 of them in the can, as they say. And we're, third to midway through the 8th. So we're working hard on it. I'm not going to say a specific date because we've passed a few of those that we hope. This has been the biggest book project I've ever tried to do. But it is really the organization of the book is that we attempt to develop, drawing on history in the United States, a notion of what predation is and how it works and how criminal legal institutions and practices fit into it in various ways and have fit into it in different ways in different eras. And then we analyze sort of what's happening in all these areas. So, for example, one of the things I didn't talk about today was the rise of other predatory businesses relying on courts and jails to enforce debt collection in those ways. So there's all these interesting things. And then, in some ways doing historical explanation and consequences in the political struggles. So our hope is to wrap this up in the coming year and hopefully get it off to the press.
That's exciting. I think it's something we're all looking forward to reading.
Thank you. Thank you. And thank you so much for having me.
Yes, thanks for being here.
Yeah, great.
Yeah, it's been a great discussion. And, I just hope that these discussions continue, and I'm sure they will, unfortunately. But thanks for bringing all of this to the table and for your incredible work. We hope to see you back here one day.
That sounds great. Thanks so much for having me. I really appreciate it.
All right. Take care. Thank you. Thanks.
Thank you. Bye-bye.
Bye-bye.
Bye.